Are a lot better. We love one another very much, and we're living in a much nicer place. We live in a good, quiet neighborhood. No hassles, no problems. Very relaxing, very healthy neighborhood. So I was arrested at my new residence a year later, August 2007. Fortunately, the arresting officers in that case were very nice. I certainly can't say that about a lot of officers I've dealt with, and they tried to get me to talk about what had been happening, and I was so frightened um, from what had gone on before at that time. I was too tongue-tied to really tell them much in detail of anything, but they were very understanding. So I was held overnight in jail and let out on conditions, and I had to appear in court that following September for a preliminary hearing and to be issued court particulars, so okay, which is papers stating why you've been charged, arrested, and what the charge is. And the law of the land, folks, okay, in case some of you don't know that, the law of the land, according to the statutes of the Supreme Court of Canada, is fair and full disclosure. That is when an arresting policeman gets a recommendation from the Crown Counsel for an arrest, the police person in question has to issue reports, okay, and in those reports there has to be contained a reason as to why, okay, and those supports must be submitted into the court particulars. No exceptions to this rule. Fair and full disclosure in each and every and all cases, folks. This policeman didn't do that. I was leafing through the particulars, going like this, and I'm figuring, well, that's strange, and standard procedure dictates that there's supposed to be a report, and there's no report. I had to go down to the police station. I had to fill out a form, and I'm just looking around for it, for access to private information under the Act in order to get the report. Okay? Now the reason for the statute as outlined by the Supreme Courts of Canada is because without this information, okay, the defendant is not prepared in many cases to fully arm themselves with a good defense, okay? Without the report, that leaves a defendant unable to make a sound defense in his or her case. And this officer knew this. He withheld this evidence and information from me. Not only that, but he falsified the report. In the report, he claimed that I was yelling, I was belligerent, I was hostile, yelling at him repeatedly, and the mental health nurse to go away, which I wasn't. And to make matters worse, I found out later on that the mental health worker in question, maybe there's some of you out there who have had experiences with emergency mental health services and who have had problems with registered psychiatric nurse, or RPN, Adrian Altman. I wouldn't doubt it for 1 minute. So, to make matters worse, the nurse lied in conjunction with this corrupt police officer, echoing what this officer was saying. I took the report to professional standards and didn't have much luck, as the sergeants there's no longer, internal affairs no longer handles these investigations. It's professional standards now, people, for you, those of you who didn't know it, and had no luck there either. But fortunately for me, later on down the road, in concluding, in his conclusive report, his reasoning for claiming my, for finding my claim as unsubstantiated, the acting staff sergeant messed up. And he might as well have just tightened that noose, proverbial noose, around his neck, and that of the offending officer made it a little bit tighter. In black and white, he claimed that the acting officer had no obligation to submit his findings to the Crown or his reports, and the Crown had no obligation or responsibility to disclose that information.